I'll start.
Good evening. This is the Planning Board meeting in Newmarket for May 20th, 2008. Would you please join me in the Pledge of Allegiance to the flag? Pledge allegiance
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you very much. We're going to change the agenda a little bit. As you may notice, we don't have a chairman. And one of the agenda items is that we elect a chairman and a vice chairman at this point. We have two new members of the Planning Board. Welcome, Val.
Thank you.
And George Willant was called away on a business trip, but he's the other new member of the Planning Board. So we'll go with 5 and see if Chester shows up. So we're going to have elections of the chairman and vice chairman now. He's in Poland. Oh, well, I guess we shouldn't wait for him then. Thank you very much. Okay.
Nice, Vicki.
So with the agreement of the Planning Board, why don't we move forward with the election of chairman and then followed by the election of vice chairman? And I would open the nominations for the position of chairman. Peter.
I would like to nominate John Badger as chairman.
I'll second. That was easy.
Yeah, that was easy. Are there any other nominations? Then the nominations are closed. I'll call the nominations closed. All in favor of?
Aye.
Please say aye.
Aye.
Opposed? Abstain? Okay.
That's how it's done.
Thank you very much.
We know how to get things done, Mike.
Yeah, we don't worry about that.
We can do the
All right.
official changing of the,
I'm not sure what I've gotten myself into yet, so we'll see. All right, now we'll have open the nominations for vice chairman, please.
I nominate Peter Roy.
second.
Are there any other nominations for vice chairman? I'll close the nominations. All in favor of Peter Roy as vice chairman, please say aye.
Aye.
Aye. Opposed?
He's looking at you.
And abstentions. Okay, thank you very much.
Stay in your
Thank you, Peter.
present seat.
Yes, I'd like to.
Make it official.
Now we'll move to the next agenda item, public comments. Are there any public comments that we should hear?
Mr. Chairman, members of the board, my name is Jack McGee. I'm an attorney from Portsmouth. I'm here tonight representing Janice Wood and David Contarino. And I want to first offer my congratulations or condolences, whichever way you want to take it.
Thank you.
But on their behalf, I just wanted to raise something with the board concerning something that has developed since the, well, it's been developing for a long time, but it involves a subdivision application which was made and conditionally approved by you last March, which involved 71 acres of land at the Moody Point subdivision, and particularly the Lubberland Creek section of that subdivision. As some of you may remember, there is 71 acres of land which borders the estuary of Great Bay that goes up to various lots of the Lubberland Creek subdivision. And in March, actually in April, my clients contacted me. It was closer to May 1st, because at the March Planning Board, Walter Cheney, as an applicant, was granted conditional approval to subdivide that land into 2 parcels. One was about 3 acres. It was a 20-foot strip along the estuary. The remaining portion involved other open land, which was part of the original Moody Point subdivision. When my clients contacted me, they advised me that Mr. Cheney, and they were negotiating with Mr. Cheney was attempting to sell the land that was conditionally subdivided back to various owners who abutted this common land. And when they told me that, I was confused, because usually in a situation such as this, when you have open land, when the subdivision is developed, it is land that goes to an association connected with the homeowners. So in fact, I did pull out the file on the particular matter that I had done the title for my clients, and I pulled out a plan that was referenced in their deed, and I have copies, if you want, of sections of it. And essentially, this is the last plan that I was able to find that involved the Moody Point subdivision. It's a plan that shows the lots. My clients own 2 lots where I'm pointing here, and there are a number of other lots, and it is the owners of these lots that Mr. Cheney is trying to sell this open land, with the exception of the 20-foot strip that he intends to donate to the Nature Conservancy. Now, the reason I show you this plan that I pulled out, this plan was approved by the Newmarket Planning Board on January 24, 1995. It related to a file 94.09, which would seem to indicate it was an application for a plan approval entered in 1994. And it shows in 2 areas here that this 71 acres is owned by the Moody Point Community ASSOC, Inc. Now, my understanding, and there are legal issues involved in this, but there are also regulatory issues, and that's why I'm before you tonight. It's my understanding when somebody presents a plan to you as a planning board, and you accept it and you sign it, which you did through your chairman, looks like John somebody, I can't read who it was, that various indices on the plan can show dedication. And it would seem to me that a representation was made to this planning board in 1994 and 95 that this land was to be deeded to a homeowners association. And that is backed up by a deed which Moody Point Company, which, as I understand it, the principal of Moody Point Company was, is, and always has been Walter Cheney. And on or about October 31, 1994, which I would assume was during the pendency of this application for the approval of that subdivision plan, Mr. Cheney conveyed 11 lots, including my client's lots, and the other lots in the Lumberland Creek area, to J. Howland Enterprises Limited. And so this would be a base deed for my clients going back to 1994, as well as other lot owners in that subdivision. That deed, on page 2, paragraph 2, says, "The open space as shown on said plan," and they are referring to a plan that predates the plan I just showed you, but it shows the same open space. It shows it owned as being by the Moody Point Company prior to January 24, 1995. But anyway, "The open space as shown on said plan shall be conveyed by the Moody Point Company to the Moody Point Community Association, Inc., for the use of all owners of properties within the Moody Point subdivision, subject, however, to the provisions as set forth in the deed conveying same to said community association, to be recorded at the Rockingham County Registry of Deeds." Now, it's my understanding that that was never done, that somehow Moody Point Company never conveyed, as was represented to you in 1994 and 95 that would be done, and it was represented to Mr. Howland in 1995, and indirectly to my clients and other people. I understand that somebody just wasn't watching, and it actually got conveyed not to the association, but to Walter Cheney individually. That's my understanding. Now, the situation I've just explained to you creates a host of legal issues, but I'm not here tonight to even mention the legal issues. I'm here to mention the regulatory issues. It would seem to me, and perhaps you can discuss this or refer it to town council or review your own records with the planning department, that a dedication was made in 1995 of this land to the association, and given that, and given the fact that you approved the plan, how hasn't the association gotten this land which they're supposed to get? That's what I've told my clients. I don't understand it from a regulatory standpoint, and apart from that, I don't understand it from a legal standpoint. But again, that's different. But it would seem to me that this board would want to assure that commitments and promises that were made in 1995, upon which I believe my clients as well as other people relied, are enforced by the town of Newmarket, and that this land, whether it be one parcel or two parcels, ends up where it was said it was going to be in 1995. That's all I'm here to say. And I think that that has to be investigated, and my clients would formally ask you to investigate it and tell us what happened from a regulatory standpoint. And that's all I have to say, Mr. Chairman. I appreciate the board's listening to me. And if there are any questions, I'd attempt to answer them. I do have copies of the plans if you need them.
That would be helpful.
What I did, I've got for you 4 copies of the deed that I referenced, which is a Moody Point Company to J. Howland Enterprises Limited, recorded at book 3077, page 500. I have 4 copies of those. Would you like me to give them?
Just give them to the town planner here.
Okay. Now, what I also did, I don't have the capacity at my office to make full-blown sets of plans of this size, but what I have done, I made 4 copies four copies of the portion of this plan, which is recorded in the Rockingham County Registry of Deeds as Plan D-23691, which shows the legend. The plan was prepared by William Doucette, who was Mr. Cheney's surveyor. It shows in the upper right-hand corner, it was approved by this planning board January 24, 1995, signed by the chairman. It shows the open space in question with a designation of the Moody Point Community ASSOC, Inc. And on page 2, it gives a plan number, and it shows some more of the lots. It doesn't quite show the whole thing, but it gives you an idea, and it certainly gives you enough material to reference easily on your own home computers or the town's computers, the records in the Rockingham County Registry of Deeds, which are online. My clients want to see this to be association land. They don't understand how a private individual can offer for sale something that should be an association property. That's their confusion.
Are there any questions from the board members? I'm sorry.
I'd just like to have time to read it and,
Sure.
like you said,
I would like
research it.
to offer some information to the board and also to the attorney. When this subdivision
Excuse
was...
me, do I need to step down? Because I have a conflict, I'm one of the abutters,
Yes.
so I said I step down at this
If
point.
you would like to, yes. Thank you. Then the record should reflect that, Erica. Okay. Just information for the planning board. The zoning regulations that were in effect at the time were called the Alternative Design Subdivision requirements, which is sort of a precursor to our open space and conservation ordinance that we have in effect now. And one of the requirements of that ordinance is that the remaining land in the tract, which has not been built upon, shall be reserved for common open land to be held in some form of ownership or easement which will prevent it from being further subdivided. So I wanted to just point that out for the record, and I'll share that with the good attorney. And I would recommend that this matter be,
Okay, I didn't know if I
could come up to the podium here.
We're relaxed here.
I would recommend that these documents be reviewed by our legal counsel and that he provide us with some advice, and that as an interim measure that we hold off on signing the subdivision plan until we get some clarification on this.
I would agree with that. The application from Mr. Cheney to subdivide has a life of 6 months, is that correct?
That's correct.
And we would hope that this can be resolved within that 6-month time frame.
Mr. Chairman, can I possibly just say a word?
You'll have to come up to the podium, please.
Okay, thank you. Excuse me.
And please state your name and your address.
My name is David Contarino, and I live at 119 Cushing Road at Moody Point. And I just wanted to embellish a little bit what Attorney McGee had said, but we have other homeowners here this evening. I want to share with the board what precipitated what's happening here this evening. I attended the meeting, I believe it was in March, when you approved the subdivision. During that meeting that evening, it was our impression when we left that Mr. Cheney would be deeding that land over to the homeowners association. Subsequent to that, he came back to us and was asking a ridiculous amount of money for that property. We entered in negotiations, he was just unreasonable. We couldn't find anything. How did we get to this point? We've lived there for 4 years, and during that time, we've been denied access to that land. We don't have, that land should belong to our homeowners association. We have not been allowed to trespass on the land. We have not been allowed to have view easements that other homeowners have at Moody Point. He's totally taken that away. And I guess Janice and I feel very caught because we pay very high taxes to the town based upon those views and the value of that property. And we just feel very, very, very much trapped right now, and we really need help. That's why I wanted you to know why we engaged Attorney McGee, because we just felt we could not get anywhere which was fair and open negotiations, and we didn't know how to approach this, so that's what, I wanted you all to know a little bit of background, what was going on. And we do have other homeowners here, and we have the president of the Moody Point Homeowners Association here also as support for this evening. Thank you.
Thank you. Are there any other comments from any other interested parties?
My name is Debbie Grubbs. I'm a homeowner on the Loverland Creek and living next to the Conarinos. When we purchased our land, which is in September of 1998, in the warranty deed, when it specifies the 4 borders, one of the borders is listed as running along said land now or formerly of Moody Point Community Association, Inc. So we assumed, and always have assumed, that that was Moody Point Community Association land. I just am, this is in support of the position that there's so much ambiguity that I think, I agree with Diane Hardy that something needs to be looked into very carefully. And I could give you, I could copy this or something if that would be helpful. Do you have
the
that?
first page of it. I don't have the entire deed.
No, that's all. I mean, I think that's all I'd probably give you, but
Okay,
If you-
that's fine. And
Okay.
I'll send this around, the board can peruse it. She is correct, it does make reference to Moody Point Association land.
as one of the borders of our land.
Yes.
Are there any other comments from, yes, sir?
My name's Jim Fitzpatrick. I'm the president of the Moody Point Community Association, and since I moved to that area in about the year 2000, 2001, it was represented to me, it was represented to prior presidents of the MPCA that what we termed Lot 6, which was kind of a generic term for the entire area, would be turned over to the association. Subsequently, inquiries into when this would happen, we were told that, well, wasn't going to be anymore. And never given any official notice or otherwise on that, much to the disappointment. People had bought properties based on the presumption that that was MPCA land. So that was my understanding. And we've wondered, I spoke last time at the offering when the developer was going to give the 39 acres. The 39 acres, the Conservancy, that I thought it was a generous thing. It followed the view that it would be preserved as open space, and that was our position. I was stunned to find out that this land was now for sale, whether they're our neighbors or not. I didn't know that the open space could be sold to any one person in that way, when it was supposed to be a piece of the overall subdivision. Thank you.
Thank you. Any other comments on this? Yes, sir.
Russ Simon, 510 Cushing Road. In reading the minutes of the last session, it seemed that there was conditional approval provided on breaking up the land into 2 pieces, but that land had to be deeded to either a community association, the MPCA, or the conservation group, which had refused this small partial of land. How is it possible someone could try to reparcel that 3.9 acres and sell individual pieces
Is that part of the approval that the planning board gave? And if this is news to the planning board, I'm personally aghast that somebody could split up a property, have the ability to turn around and then try to apparently blackmail several people into buying pieces of the land from him that I don't believe he has the right to sell. Was the planning board aware of the plan to sell and further subdivide this property? Okay, thank you.
Thank you.
Yeah, I just wanted to clarify that in the ordinance that was in effect at the time, it doesn't stipulate that the land has to go to the homeowners association. It provides different options, and it's up to the planning board to determine whether or not the conservation values that are being protected as part of that conveyance. It could be, the land could be conveyed to a conservation group or to a homeowners association. And I think the feeling of the planning board at the time is that what was being proposed, that it go to the Nature Conservancy, and there were very strict conditions placed on that approval, i.e. that the remaining conditions, that i.e. that remaining land would have to go into the hands of an organization or the homeowners association, and that they would have to provide legal documents to the town to prove that that condition had been met before the plans had been signed. So at this point, it's a conditional approval, but the plans have not been signed, and they will not be signed until those conditions are satisfied, if they are able to come up with a reasonable plan to do so.
Yeah, in defense of the planning board, at the time this was conditionally approved in March, this information was not placed before the planning board, number one. And secondly, the planning board had no idea that the applicant would be trying to sell those 3.7 acres. It was conditional approval, and as I said earlier, the conditional approval application has a 6-month life, and I would hope this can be resolved between the town of Newmarket's legal counsel and user, and I think that's the way we're going to go.
Just a point of clarification, Mr. Chairman. Mr. Cheney, in all fairness, is attempting to sell the whole thing to a group of people who are private landowners. He's not offering, as I understand at this point, slots. He's told a group, you can buy it, and if all of them don't want to buy it, he's going to try to sell it to some of them, but he's not going to divide it up. He can't. But just for clarification.
That's the 3.7 acres or whatever.
I think that's the bigger piece. I think the 3 acres was the strip.
Along Leatherland Creek.
And it's about
and
69 acres or something.
Yeah.
I thought that was
It's the bigger piece.
That's going to the Nature
That's
Conservancy.
proposed to be conveyed to the Nature Conservancy.
69 acres?
Yes.
Yes.
Oh, so it's
So we're only talking,
it's reversed? Okay, I'm
It's the
sorry.
3.9 acres that was up in the air, that he didn't know who he was going to convey it to.
Right,
Which a
okay,
small portion abuts behind the
Right.
homes.
right.
And I do have the subdivision plan here, and you're welcome to review that.
As I said, we're only here because of the regulatory issues of what happened in 1995, and it seems that the planning board in 1995 saw and approved this was going to go to the homeowners association. And, but in terms of other issues, of course, that's between Mr. Cheney and the homeowners. But we did want you to be aware of it, and thank you for your attention.
well, we appreciate that. Thank you very much. As I said, in the March meeting, the planning board was not aware of these issues. Are there any comments from from members? Peter?
I have a comment. I was confused by this because at the time the Nature Conservancy was here and presenting their portion of the subdivision case, if you will, they insisted that they did not want to take the strip that went behind the homeowners and between the homeowners and the marsh, or that portion of the bay, because they didn't want to abut private property. They'd had problems in the past. They didn't want to have any problems in the future. And then, lo and behold, the Nature Conservancy would be the beneficiary of the 20-foot strip, as I understand it, that runs along the bay or along the marshland there. And it was that portion in between the existing lot lines of the individual homeowners and that 20-foot strip that was being offered by Mr. Cheney to the homeowners, and that would then become private property and abut the Nature Conservancy land. I don't know where the Nature Conservancy lines up on this or whether they gave it any thought, but they're going against the very thing that they said they didn't want to do.
I briefly spoke with Dwayne Hyde, who is one of the conservation specialists at the Nature Conservancy, and he explained to me that they're using the donation of land from Mr. Cheney to the Nature Conservancy for match purposes so that they can get, I believe it's federal funds, to make other land purchases in the Great Bay Area. And in reviewing the land, it was their opinion that the land that directly abutted the property owners was not valued the same way or at a premium as the land which is directly part of the Lumberland Creek is with respect to, wildlife habitat. And for that reason, plus there had been some alterations in that area, some tree cutting, some encroachments, and that for that reason that it wouldn't be valued as high. So it was pretty much a programmatic reason on their part why they chose not to include that. I've since spoken to Mr. Hyde about it, and I believe he's going to get in touch with the landowners to see if there might be an opportunity to maybe reconsider that decision. I hope that comes forward. And I believe from my discussions with the property owners that they would probably be pleased with a conservation organization owning the land as opposed to even having it be turned over to the homeowners association. And I don't mean to speak for the homeowners, but I believe there may be some further discussions with them along those lines. So my hope is that we'll be able to reach some kind of satisfactory resolution to the problem.
Great. Well,
Sorry for the delays, but I just want to embellish what we've been talking about. When you look at the value of that property, by taking away that 20-foot strip and trying to sell to the homeowners, it really devalues the property because obviously we would like that to embellish our property, but denying us access to that 20-foot strip, it really devalues our property. And it seems to me that Mr. Cheney's trying to serve two masters. He wants to give the Nature Conservancy what they need to fulfill their needs. He's making financial reward by it, and we're left with a piece of property that's really worth nothing. So that's really, I just wanted to say that. Thank you.
It's my understanding he's donating the land to the
Yes.
Nature Conservancy. It's not a
That's right, and he's going to participate in a very nice tax benefit from it. But that's his business. That's up to him. Thank you.
thank you. Yes, sir.
Just as a follow-up, Diane, and to the board, I'm confused, which this apparently is confusing a lot of people. But if, in fact, the attorney who addressed the planning board is correct, and this land was approved to be given to the Moody Point Community Association, Inc., in both 94 and 95, and was represented to the people who own land as land that was owned by the Moody Point Community, how could a deal be worked out giving it to the Nature Conservancy, much less having the Nature Conservancy work another deal if in 94 and 95 this was already approved? It's just a question.
The ordinance that was in effect didn't nail down a specific option. It says that the land can be conveyed to a homeowners association or to a conservation organization that fulfills the conservation purposes
Well,
of
that
the
was the
open space.
document, but the warranty deeds that were provided on
Oh,
the
and
property,
that's-
on the maps, and to the
Yeah.
individual homeowners when they bought the land specifically said the Moody Point Community Association, Inc. I'd just like to bring that to your attention again, because it seems, if that's true, then the rest of it appears to be
Right.
somewhat moot.
And that's what we're going to have the town attorney address.
And I'm addressing it from a regulatory standpoint, not from, a civil action standpoint. So that's my perspective. Not that I'm not sensitive to your concern.
So with the agreement of what appears to be a rapidly diminishing number of members here, I would recommend that we, as a board, do not take any action on the final approval of the application until this matter is resolved from a legal standpoint between the town attorney and this gentleman representing the landowners. Is there a problem with that? Do we need to take that to a formal vote?
I would not take it to a formal vote because we're here listening for information, and I will forward the information to legal counsel based on our discussion.
And should the town council be aware of this also?
Yes, let's bring that to their
We'll make the
attention as
town
well.
council aware of it also. Anything else, sir?
No, Mr. Chairman, thank you very much for your time and your patience. Appreciate it.
Thank you. Are there any other public comments before we move on to the other items on the agenda? The next item is the review and approval of the minutes from the meeting of April 15th, and I have been advised that we don't have those minutes, so I think we're going to pass on that. The next item on the agenda is the Newmarket School Department discussion of school land. Is there a representative here? Yes, good.
Secretary, I hope. My name is Peter Bronstein. I'm with the law firm of Sol Leslie Kidder that represents the school district. We're here this evening to discuss the school district's desire to acquire a portion of the land which is behind the elementary school. The land is presently owned by the Durrell Woods Community Association, Inc., as described in the warranty deed, which is the first exhibit with the material that I provided to you. In the warranty deed, to give you the Reader's Digest version, is a reservation whereby AWL Power, Inc. can require Durrell Woods Community Association, Inc. to deed back to it a portion of what's known on the plan, which is the next exhibit, as Lot 72, which is the open space that was created as part of the Durrell Woods subdivision. Now, the restriction is that that it be given to the town of Newmarket or to the school district. At this point in time, the request would be that it be given to the school district. The exact portion of the land has not been delineated by a survey yet, but on Exhibit 3, the plan for is a site plan, a conceptual site plan for the expansion of the school, and where you see the area labeled proposed athletic field, and that whole rectangle, if you will, extending from east to west, is now part of the open space. The last exhibit is merely a floor plan of the proposed addition and renovations. There have been ongoing discussions with Diane Hardy. I think the previous superintendent and the present superintendent have had some discussions with her. I think there's been some difficulty in finding some of the records with respect to the subdivision because it's understandably so. It's a number of years ago. But the use basically would be for that athletic field, and there are no other plans at this point in time. As I understand it, based on the topography and location of this land, would have a minimal effect on the Durrell Woods community in that it's, I guess, fairly steep, and there are wetlands beyond the portion that would be usable by the school district. And so we're here really on I'd really call it a preconceptual basis, because we don't have a surveyed plan to show you, and we just wanted to truly just discuss the concept.
Are there any issues regarding the conveyance of the property? I noticed Mr. Cheney's name seems to be on this somewhere.
He is. He has consented to it. Let me step back. He was owned the controlling interest in AWL Power, Inc., and I believe was, if not the sole shareholder, had the controlling interest at the time that it was dissolved. He has approached the school district and indicated that he would consent to this conveyance. Obviously, it would involve the Durrell Woods Community Association also. And so we'd have to, have this discussion with them also.
And that's an ongoing homeowners association?
As I understand it, the answer to that is yes, but I'm not so sure that it's, ongoing in that I think it's
An
still,
active group?
still an entity. I don't know if it's an active group.
But it's still a legal entity,
I think that's correct.
which I presume would include officers and so on? Okay.
In the individual deeds of the Durrell Woods subdivision homeowners, is there reference to this warranty deed that references the other agreement for Mr. Cheney to take land back to convey it to the school district?
I think there's a
mean,
reference, and I can get you a copy of that. There's a reference to, as I recollect, to the protective covenants, which reference this reservation with respect to Lot 72. And then the reservation itself is memorialized in this deed.
So any homeowner who purchased in that development would have been aware that there was some caveats associated with their open space, and that part of it could at some point be taken away and deeded to another entity?
They
To the
should.
school district? I mean, are they aware of it? I guess
They
is the question.
Okay. I guess they should have.
Suppose it's a
They should have
different
been.
help. Okay.
Whether or not they were.
Should have been, yeah.
Yes, I mean, it was on the record. I do a lot of real estate conveyancing, so I'd hate to answer your question that, yes, they were aware of it. But they should have been, if they had read through the protective covenants, had them explained to them. They do lay it out that it is subject to that reservation.
What are your next steps now?
Well, we wanted to get the input of the planning board, because it has been discussed now, I think for about a year, just in concept. And we would probably have the surveyor lay out a survey of the land, and then discuss that with you and with the Durrell Woods Group.
But you would have to get the Durrell Woods Group Association, the homeowners association, to sign off on all this? Or certainly you have to make them aware of it.
Yes, yes.
And
Sure.
it's for ball fields, basically.
Well, it's just, at this point, it's Exhibit 4, the conceptual site plan. It's really just for that one proposed athletic field at this point,
Okay.
which is, I believe, 150 feet by 240 feet. There may be more land that's conveyed to the school district, but as I understand it, the land has significant restraints with respect to future uses, based on topography and
Okay.
wetlands.
Wetlands, okay.
It's wetlands on this ledge.
And ledge.
I know the land.
Okay.
John?
Like this.
I just wanted to mention to the board that I did locate the original subdivision plan for Durrell Woods, and there is a notation on that plan that the open space shall not be subdivided. So if this project proceeds as we all envision, there would have to be a revision to that subdivision plan to allow the subdivision and to allow the conveyance of the land back to the school district.
So the original
Subdivision
Durrell Woods subdivision
plan would have to be
plan
amended.
would have to be amended, correct?
If we did it by easement, would that still be the case? Under your ordinance?
It's a legal question.
Okay. I mean, different
our
towns treat that
Our
differently.
subdivision regulation talks about the division of land, and if it's a lease hold interest, then it does require subdivision approval. We'd have to look at the definition carefully.
Okay.
I think that might be a preferred approach.
Well,
Does the deed restrictions under 4A and B affect the proposed intent of doing the subdivision? For the public specifically, that no buildings or other improvements, except easements ascending for utilities, shall be located nearer than 100 feet from the boundaries of the single-family house lots.
Any improvements would honor that.
And the same that no more than 50% of the Lot 72 would be affected by the easements or
That-
conveyance.
That also.
So that would all be
Yes.
met.
Yes, those two would be met, definitely, yes.
are there any other questions? Okay.
All right. Should we be back in touch with the town planner with respect to the easement question? Is that the best
I think that would be the best.
proceed? Okay. Thank you very much.
Thank you very much. Are there any comments on this from the public? Yes.
Roseanne Quox, Wildley Falls. In light of the fact that another subdivision is proposed on land that's supposed to belong to an association that was created by Mr. Cheney, I think before anything further is done, that it should be looked into legally as well to make sure everything is in proper order, so we don't walk down that same road that we're doing with the Moody Point folks. And probably if we keep finding these situations with Mr. Cheney, I strongly suggest that our legal fees for looking into this convoluted mess that we have with him be charged to him to pay, so the town doesn't incur the expense. Thank you.
Thank you. I did have one other question, sir. Did you say that AWL Power, that legal entity, had been dissolved?
That's correct, to the best of my knowledge.
So it doesn't exist anymore. So AWL Power conveyed the property back to Mr. Cheney?
As the
Or-
law existed at that time, and it's a little different now, the property, the title to the property became the property of the shareholders.
Okay.
All right. And as I understand it right now, Mr. Cheney was the sole shareholder at the time of its
So it's basically...
dissolution.
Yeah.
But the title itself at this point is in the Durrell Woods Community
Durrell Woods,
Group.
right, okay.
Yes.
Okay, thank you.
Thank you very much.
Any other comments on this particular issue? Right, then we'll move forward. Next on the agenda is public hearing for the trimming and removal of trees on Bay Road, a designated scenic highway. The applicant is PSNH. This would be Bay Road. The purpose of the activity will include but not limited to tree cutting, trimming, and possible removal. Good evening.
Good evening. I'm John Kavanaugh, the Supervisor of Vegetation Management for Public Services in Hampshire. PSNH trims over 2,500 miles of roadside distribution lines every year. Our objective is to have trees and power lines coexist safely. We trim each circuit or each road approximately every 4 to 5 years. Bay Road was last trimmed in 2004, so it's been 4 years. The trimming contractor that PSNH uses is Asplin Tree Expert. They're required to have qualified line clearance trimmers, which is a technical term, that are trained specifically in proper arboricultural practices. We're here tonight to, as part of the overall circuit is being trimmed, since Bay Road is a scenic road, to get permission to go ahead. You should also realize that we seek permission from each abutting landowner as well as, in this case, because it's a scenic road from the town. In addition to just trimming trees, we also identify any hazard trees. In this particular road, there's 16 dead or dying trees have been identified that could be a risk to power outages out there. I do have a list of those trees if the board is interested. And beyond that, I'm just available for any questions you may have.
For the information of the audience and the folks who are watching on television, the state RSA requires that PSNH get approval from the planning board to trim on a road that's been designated a scenic road. So that's why the gentleman is here. It's required by the state law. Are there any questions? Peter, Val? Comments? It would be helpful for all of us if you could explain. I had the opportunity to look at a pamphlet that you apparently give to the homeowners. There's some photocopies of it.
Oh.
And if you could explain the clearances that you
Sure.
propose and why these clearances are necessary.
Sure. The proposed clearance that we seek, and again, it requires permission of the landowner, but it's 8 feet to the side of the conductor, which is the top wires are our wires, 8 feet to the side, any limbs 4 inches or less in diameter, 10 feet below the conductor, and 15 feet above. The reason for that, I mentioned, we trim every 4 to 5 years. You can expect probably 2 feet of growth per year, primarily hardwoods that resprout. And the reason for the 15-foot overhead is for heavy wet snow and ice, trees bowing down onto the power lines. So it's a combination of getting the clearance. Public safety is one of the major concerns. Trees are a conductor of electricity, so we want to get adequate clearance for that 4 to 5 year window.
What is the size of the tree? Is there some size restriction or some limit that would require you to cut a tree down, as an example?
No, our specification is for limbs 4 inches and below. Since we've been on more of a cycle maintenance program, the pruning technique is a directional pruning. They're taking away the limbs that are growing towards the lines. For example, if you've got a tree here and limbs growing toward the line, if you start teaching the tree to grow away from the line, there's less and less that needs to be pruned. Bay Road is probably a pretty good example of it. Most of the road looks pretty good. That really there's minimal trimming in a lot of the area because it's been directionally pruned in the past. So the specification is 4 inches or less. Of course, if it's a hazard tree, a dead tree, then regardless of size, we seek permission to remove it.
Mike?
In regards to the seeking permission, what if a landowner doesn't give you permission? Then what's the process?
Well, the state statute does allow a process. We hope we're able to come to some kind of an agreement with the landowner without going through that process. But again, our objective is public safety, and of course, if one landowner is putting the public at risk or reliability of the rest of the circuit at risk, then it may be something that we would want to pursue. The recourse is to petition the town. The selectmen would have to hold a public hearing and notification to the owner, and the selectmen would determine whether it's in the public good to have that area trimmed. That's a recourse seldom used. Usually you can work things out with folks.
And do you have like a minimum lead time that you let these property owners know prior to being on site?
Not really. In some cases, it may only be just ahead of the trucks, but in this case, this particular case, we probably will not be in Newmarket for a couple months, and they're in the permissioning process now.
They are, okay.
Yes.
So there is time for the landowner to react?
Oh,
They
yes.
so
Oh,
choose.
yes, yes. Oh, absolutely. They cannot touch one of those trees without the owner's permission. So if an owner hasn't responded or whatever, then they have to just go right by the spot.
You said the last time it was done on Bay Road was 4 years ago?
Yes.
And then I presume 4 years before that?
Getting a little foggy then. We didn't have a real good maintenance program in the past. We're starting to get in, I think around 2000, we started to get in a regular cycle. Before, because of financial problems, it was more hit and miss in the real hotspot areas. But now we're in a regular cycle, have adequate funding to be able to continue that way, which I think is to everyone's benefit. It's a lot less drastic trimming if you can keep that cycle going. So I think things will look better than they had in the past.
Yeah, Val.
When you're addressing the dead or diseased trees, are you taking down the whole tree to the base?
Generally, yes.
And
Unless the owner wants it there for woodpeckers or whatever.
That would be the Nature Conservancy.
Could be.
And when you're seeking approval from the owners, is it that you're seeking approval from the stone wall in, their actual boundary, or in the
No,
area
we've got a
in front
very
of you?
loose interpretation of what we're required to do. Essentially, if there's a tree, I mean, it could be right up against the road. We interpret it that we need their permission.
Even though it might be on the town right-of-way? Okay.
Yep.
Peter?
Just a couple of things. First of all, I admire the work that PSNH does every time the lights go out and they come on within a reasonable period of time. And so I'm grateful for the fact, and I recognize the fact that the maintenance has to be done, because with the severe weather conditions that we have and so forth, we can experience power loss if it's not done. A couple of things. I wanted to ride down Bay Road and did, and I was impressed by the fact that there were a couple of trees, very, very large trees. I think they were pine, I'm not sure. But they seem to have been chopped off at the main trunk, and then one branch would go out around and so forth, and it's dead. And I'm wondering why those haven't been removed.
Is it on our list? I don't know.
I wouldn't know them by address.
Yeah.
But I did see them, and it's obvious that they've been there for more than 6 months and maybe more than 4 years. I don't know, but
Yeah.
I would suggest that be looked at.
Okay. I did ride the road actually a couple times since the hearing's been scheduled, and it may be that we've got it here, but I can take a look.
Any other questions? Any comments? I had just, how, this 8 feet, 15 feet, and 10 feet, just how firm is that? That's what you'd like to do, or?
Yes, but oftentimes, I mean, every tree's different. I mean, you'll see some leaders that are this size, and they may be within 3 feet of the line. We're not taking that leader out unless there's some decay or disease or some other reason. Every tree's, pruning every tree is a little differently than, that's, the little picture, you don't necessarily see it there.
Yeah, I'm sure that the property owners don't want to see half a tree there, or a
Right.
tree with a hole through the middle, that kind of thing.
Yes and no, but, I mean, you do have to get some clearance, otherwise it'll grow right back in. So you will see a number of trees that are, they're splitting the line. Some of the big maples around, you'll see them on either side of the line. They've had the middle taken out from pruning, and they just have grown around. You'll actually see them grow right around. Unfortunately, there are trees located where they shouldn't be, and we try to accommodate them.
When you go to the property owner, to get their permission, do
Yes.
you explain to the property owner or attempt to explain to the property owner exactly what you're going to do with the trees on his property? So he has a clear understanding of what's going to happen?
I personally don't do it. It's a contractor that does it, and I happen to know that the individual that did Bay Road and is doing Newmarket is a graduate from UNH in the forestry program, and do a nice job of explaining things.
Okay. Any other questions? Thank you very much.
Okay. Pardon?
May I have one?
Absolutely. This is a little handbook that the trimmers actually have, so if you're really interested.
So what we should do, other type of new developments, is make sure everything is done
Underground.
underground, then we won't have the regular maintenance and upkeep, really.
Are there any public comments on this? Yes, please.
Roseanne Cox, Wildly Falls. I was just wondering, when the tree trimming is occurring, is there an independent certified licensed arborist with them during the cutting?
During the cutting, I would say no. Myself and the 4 arborists and PSNH arborists are all certified. We have a quality assurance certified arborist that goes around afterwards, so if there were some cuts that weren't made properly, he sends them back to correct them. The trimmers are trained in proper arboricultural practices, but they're not certified.
Yes, sir.
In my estimation, if they go, because it's a scenic road, designated scenic road, if PSNH goes through the time and expense of sending a certified or licensed arborist after the fact to check what they've done and to make corrections if needed, at that point, it's too late. So if you're going to go through the time and expense of having an arborist out there after, just send them with the crew to make sure that the scenic road is protected.
Sir, how many days do you think your crew will be on Bay Road to do that?
Bay Road. What is that, maybe 2 miles from 108 to Durham? The Durham town line?
Yeah, at least 2 miles, yeah, maybe more.
Well, if, let's say there's 2 crews working on it, that's probably 2 weeks' worth of work.
2 weeks.
Mhm.
Okay, thank you. Are there any other public comments? Yes, sir.
Renan Cohen, excuse me, Renan Cohen, 81 Bay Road, Newmarket. Here with quite a few concerns, not the least of which was the last comment about the arborist. I appreciate the information we're getting from PSNH tonight, and it's presented in a very kind of down-home, arboriculturally sort of friendly-looking way. But I have to say that I'm not necessarily encouraged. Bay Road is a scenic road that was so designated by the town meeting of Newmarket exactly 20 years ago, actually, this year. A group of residents from Bay Road organized a petition drive. It was presented to the town. To the town meeting. It was passed by the town meeting, and the citizens of Newmarket, as a totality, voted to have this road so designated. It's not any ordinary road, and this isn't any ordinary town. And I think that we should. I hope from some of the questions that you all are posing on the board that you share my honoring of Newmarket as a special place, and Bay Road is a special place that the aesthetics of which we want to protect and preserve. And if that means making clearances a little bit lower than they might ordinarily be, and having PSNH come back a little bit more often to promote and protect smaller clearances so that things look a bit more the way a scenic road would normally look, then I think perhaps it behooves the board and the town to act in that fashion. I do have some questions, though. that I would like to pose, and the first one is about the 16 trees that have been mentioned. I would like to know what evidence does the planning board have tonight that those 16 trees in fact are diseased, that they do pose a public safety threat, that they will be posing a problematic interaction between the power lines and the trees themselves. What pictures, what evidence, are we just going to say, well, those things exist and therefore they should come down? So that would be my first question. And I would like to remind the board, and the board probably will not know about this, but I lived on Wadley Falls Road at the time, and perhaps Roseanne will remember, but there were, I would say, at least half a dozen beautiful, very wide trees along Wadley Falls Road opposite the Walker homestead that came down through just exactly the process that's been described tonight. And some of them, it seemed to me, had no bearing on the electrical lines. They were not that close. There was no attention given to the aesthetics. They were beautiful, and they're gone now forever. And it just seems to me, before we sort of take it on face value that there are trees that are endangering public safety, that we have some more evidence as to the real lack of viability of these trees. So that would be my first question. What evidence do we have?
Well, I'll make a note of the questions, and we'll ask the gentleman to come back up, unless he'd like to answer that question now. Sir?
Sure how to respond. A dead tree is a dead tree. I have a bachelor's and a master's degree in forestry and certified arborist and 30 years experience, and dead tree's a dead tree.
Were you the individual that identified these
I did not,
16
but
trees?
I've gone out and looked at.
Okay. Right. Thank you. Next question.
All of it, it's to the contrary. I would like to know, and I've seen the operation take place, by the way, and when I was on Wadley Falls Road, I was asked as a homeowner whether I agreed with the process and was given almost no information about what was going on. I'd just like to make note of that. I've been through this process once before in a different location. I do own property on Bay Road now, and did have somebody from PSNH come to our door several weeks ago and was given no pamphlet, to my knowledge. I was there when they came to the door and asked if trees could be cut. So I don't know whether I'm going to be getting another ask from PSNH or not. I assume that I'll be getting another one after the hearing. If this passes muster with the planning board, my question is, will I be getting another ask, because I've already gotten one?
I believe you're listed as what we call a refusal. I've looked at the area, and although there are some limbs that will grow into the wires before the next cycle, I don't consider it's necessary to pursue it. So as far as I'm concerned, we'd be skipping your property.
Okay, so that's the second question. Another question I have is, I would like to understand what happens to the wood chips that are processed by Asplund on behalf of PSNH. I understand from some of the material that I've read that they are distributed to communities and used for public purposes, and I want clarification as to whether there are any commercial purposes for any kind of profit that those chips that are produced and made by Asplund and stored in their truck, which I have seen them do, were there any commercial destinations, I guess, for those wood chips?
Generally, there's a parade of members of the general public looking for piles of chips, and that's generally where they go. Some towns have them dumped at Public Works so that the town can utilize them. There's no commercial use of it, although PSNH has a wood chip plant at Newington. It's not economically feasible to collect out of individual box trucks like that and bring it over to Newington, so they're strictly available for anyone that wants them, and generally a lot of people want them.
So if the town were interested in having those available, you could haul them down to
Absolutely.
some location in town here and make them available to Newmarket?
Absolutely.
Okay.
I'll take it from that statement that there's absolutely no commercial use to which these chips will be put in Newington or anywhere else, and that the record will
Sounds like
reflect
all they want to do is get rid of them, get them out of the truck so they can fill it up again.
Okay. I guess I'd like to close by saying that my hope would be, and if I were sitting on the board tonight, my motion would have been, which I'm not, that special attention be paid to the fact that this is a scenic road, that it has special aesthetic qualities, that a lot of conservation land, including land owned by the Nature Conservancy itself, including offices of the Nature Conservancy, lies on this road, and that in recognition of that reality, that the board put forward some kind of motion that the clearances be reduced substantially, perhaps to at least half of their current value, since the town does have the aegis and the town does have the role, the power, I guess, to make their own decision with regard to the dimensions of clearances, that be done, and thereby having this kind of work done, perhaps done more often, but that the clearances be smaller, and secondly, that the board be given some visual evidence by photograph or other means that these trees in fact do need to come down before they're taken down, that they in fact are diseased, and that there's some way, arboriculturally proper way that the board can be informed, so there's no doubt that these trees are in fact in need of coming down. And I thank you for your time.
Thank you. Are there any other public comments on this issue? Mr. Kavanaugh, what, if I could ask you, we talked about the clearances that are in your pamphlet.
Mm-hmm.
Are there clearances that are, less clearances that are acceptable to PSNH?
Well, any circuit you go on, you'll see areas that have less clearance than that, and it's primarily because an owner has asked for a light trim. Can we do that? Yes. It would mean coming back sooner than 4 years. Is that cost effective? No. Is that, it's
Well, if you
customers'
clear
money.
cut it, it will be really cost effective, but we're not going to do that either.
Customers' money, and it's not the most cost-effective thing, but it can be done. And the other thing I should mention, proper arboriculture, you take a branch back to another branch. So just because somebody says take it back 2 feet, you don't want to just chop it off at 2 feet, because then you'll end up with a dead stub and cause disease and decay problems. So it's generally back to the next branch that limbs are taken to. Can it be done? Yes.
Okay.
Anything's possible.
Thank you very much. Any other questions for the gentleman? Any other public comments? I guess I'm looking for some input from the board members here. Or a motion. I mean, it's possible. Diane, do you have some comments?
Well, and I'll just convey my story. This weekend, I went down to Boston to visit my dad, 93-year-old dad, and I went through the city of Newton on my way down. And for those of you who aren't familiar with that area, it's a suburb of Boston. Well, Newton is a tree city, USA, and their suburban neighborhoods are absolutely beautiful because they have all these beautiful trees. They were probably planted 50 or 60 years ago. And at this time of year, it's just beautiful because they're all flowering trees and they're in bloom. And one of the things that struck me in driving through the residential streets is that the canopies of the trees had grown over the road and had created almost like an archway. And there are all different, varieties, crab apples and flowering cherries. And it was just absolutely beautiful. One of the things I did notice was that the clearances from the power lines were probably half of what is being proposed this evening by Public Service. And I really think, I mean, I don't know how often their pruning schedule is and if they work with, what public utility they work with, but it seems to me that other communities have been successful in regulating tree cutting activities within public right-of-ways, and that given that there's a scenic road that has been determined to be important to the town, Bay Road being that I don't think it would be unreasonable for the planning board to, if you chose to attach some conditions on any approval that the cutting be minimized to perhaps half of what is being recommended as the standard. And I think Mrs. Quox brought up some good points regarding having a certified arborist take a look at or be available to consult with the tree trimmers as needed. And also, I think we have the list of trees that are coming down, maybe having an independent forester working for the town advise us, yeah, this is, most definitely a diseased tree and needs to go. Just to provide the kind of evidence that would make the community feel comfortable with the activity that's being proposed. So those are my thoughts.
Any other comments?
Well, I don't think the town of Newmarket should have to hire an arborist. I think we should get the reports from the public service. He mentioned they're all foresters who have education and they know what the information, and if they just wrote up a detailed report for us, I think that would be sufficient instead of us going out to hire that. They're not, I just don't think we should take that extra cost on.
I will, sorry.
Well, they have the expertise right there if they just provide it to you.
I'd be happy to provide photos if that's what the board would prefer.
On the 16 trees that... Any other comments, Mike?
Yeah, I agree with the town planner as far as trimming back the measurements, side to side and height and lowering it. I mean, 15 feet above a pole seems substantial to me. If we could cut that in half, say 7, 8 feet within reason. You look at the graph, the pictures that we've got here, and it really looks like a sad tree when you're cutting something of that nature. So being a scenic road, and I understand it's not cost-effective probably for PSNH to come back every couple of years, but it's not like every road that they're doing is a scenic road or been designated as a scenic road. Sometimes you have to make exceptions. That's just my feelings on it.
Yeah, okay. Peter, Val, anything else?
I think it also might be worth having the Public Works Director look at the trees that are being removed to see if there are additional ones that are there for safety, that are impacting safety issues on some of the corners especially. There's clear evidence that many of the trees are being impacted by the snowplows.
Well, let's see if we can put this together here, and I guess I would suggest we conditionally approve this based on a couple of comments that I heard. One is that if the town of Newmarket is interested in the chips, that they designate a spot for the chips to be dumped, and they're made available either for the use of the town or to the public, or both. So that would be one condition. And secondly, that we have the clearances that are shown on this pamphlet are reduced by 50%. And the evidence that the gentleman, Mr. Kavanaugh, offered of photographic evidence and identification of the 16 trees that he designated as needed to be eliminated, that they provide that to the town planner. And is there anything else, Peter?
I'd like to suggest that, well, if we're going to cut the standard for cutting in half, that in other words, instead of it being 10 feet, it's 5 feet or so forth and so on, that we also increase the frequency of the visiting cutters to come in every 2 years instead of every 4 years, for instance.
I don't know that we can, certainly that would be
Well, your growth is going to
in
be the
in a
same.
perfect world, but this is
Growth
not,
is gonna
this is
be
not
the
the only road they're cutting, so.
No, I understand that, but your growth is going to be the same. It's going to be 2 feet a year or whatever it is, as Mr. Kavanaugh pointed out. And if you're only going to cut it back 4 feet instead of 8 in 4 years, it's going to be 2 feet over the line.
Okay. So we would see him again in 2 years.
I'm sure he's looking forward to that, too.
Right.
Probably won't be me.
Is it something we said?
And, all right, can I put that in the form of a motion with those 4 conditions? I think there are 4. Would you read those back?
Sure. That it be conditionally approved, 1, that the standards be reduced by 50%
From the pamphlet.
from what the pamphlet illustrates as clearances. Secondly, that the wood chips be available to the public and be available at a town of Newmarket facility. Thirdly, that there be evidence provided to document the 16, is it, deceased?
I think 16.
Diseased trees, so that they can be evaluated as, for public safety reasons. And,
4th, that they come back in 2 years instead of 4.
and that they increase the frequency
Right.
of cutting.
Right. Are there any?
Quick question.
Yeah, Mike.
Just a quick question, as far as seeking permission from the landowners, is that done on a verbal or on a written form?
It should be written.
It should be written.
Sometimes it's phone calls over, that they leave the brochure on a door hanger bag, and sometimes the owner just calls to give verbal permission.
Can we add that it would be written permission as opposed to verbal? I mean, I know it becomes a gray area,
People
but
aren't home, and it's, I don't know if is that reasonable? I guess that's my question. But you are sure that at least everyone is notified of what you're doing, and they have an opportunity to come back and
The contractor's liable if there are any issues that weren't
decline
covered
or
with
whatever,
the
okay.
landowner. So it's in their best interest to make sure that they
Yeah.
have the right permission.
Yeah, and I would issue the caveat that because of this, I hope that there's no electrical outages.
Well,
because
you
of-
have reduced, you have increased the likelihood if we
Right,
get a heavy
exactly
wet
right.
snow.
So it's a,
But
you know.
throw of the dice, who knows?
Right, exactly. Just so that's recognized
Yep.
by everybody. Okay. So we have those 4 conditions, and I will make that a motion. Is there a second?
Second.
Any other discussion? All in favor, say aye, please.
Aye.
All opposed? Abstentions? Thank you very much, Mr. Kavanaugh. Next item on the agenda is a public hearing for a minor site plan review, Town of Newmarket and Verizon Wireless. Location is on the water tower in Great Hill. The proposal is for the co-location of 12 antennas and an 11.5 by 30 prefabricated equipment shelter to be located within the existing enclosed compound at the telecommunication facility located at the water tank. And Verizon's looking for acceptance tonight. Approval.
You probably didn't get a copy of this. This is recommended.
Mr. Chairman, if I may, I have some revised plans I got, thank you very much, all members. We last met together on April 15th. And continue to work with planner and town council on clarifying the access issue. And also touching base with T-Mobile, sorry, AT&T Wireless, who had an installation approved in 2006 but never implemented it. And in fact, we learned today that they have now terminated their lease with the town, so they won't be moving forward with that project.
You won't have you won't have less competition up there.
For the time being. But it did give rise to a dinner time conversation with the RF engineer, and we'd actually like to, if we can win conditional approval tonight, make the condition include that we come back to you with one final revised set of plans that would erase the AT&T equipment from the site, that would also erase the propane tank from the site, and that would move the Verizon wireless antennas into the spot that the AT&T antennas were previously slated for. We met this afternoon with Michael and Peter and Diane as the technical review committee and talked about some issues, and then Chip Fredette and I actually went to the Folsom Drive access site, met with the Ransdells, and kind of walked the access route. And Diane had gone over with us this afternoon some proposed conditions that she's got a revised version of tonight. Diane, is just the addition of the last two?
Yes.
Yeah.
I restructured the access to address the town administrator's recommendation that we talked about.
If some folks may remember, we looked at this map together in April. This is from an engineering report that Underwood Engineers had done for the town, looking toward the future construction of a second water tank at this Great Mill location. And at that time, there was some talk about reorienting the access from the current employed Folsom Drive, crosses the Ransdell property, until it hits the Harper Road property and then into the site, in favor of one that would come off of Great Hill Road, which was going to split two lots that were numbered 5 and 6 on a historical subdivision plan. The town administrator reported today that that's not going to happen. The owners of 5 and 6 are not interested in having access over that right of way. It's the site of the existing water main that comes out from the tank site to Great Hill Road, and the town has rights to access that for maintenance purposes, but the owners do not want it to be developed for vehicular and pedestrian access purposes. In the course of our research and conversations with Diane and with Doug Mansfield, we discovered what appears to be a more robust easement right-of-way getting from Folsom Drive to the Harper Road property by virtue of the 1979 subdivision. When this land was first subdivided, there was a reserve right-of-way about 50 feet in width that actually takes you from Folsom Drive to the back of that property, which is more than adequate for our purposes. And frankly, for the practical impact of this is, having walked it today and met with the Ransdells, we can largely make use of as it exists today. The property is pretty firm, the ground-wise. There may be some places where we put in some crushed gravel to support the weight of the construction equipment when it's being built. And there's an existing fence, there's a wooden fence at one end of the Ransdells' kind of entrance to the backyard, a chain link fence at the back end of it, both of which have wide enough gates to accommodate our equipment needs. And there's a pretty clear road, no trees to be removed. It's nice, easy access. There is evidence today of the last time heavy equipment traversed that right-of-way. I think it was a Sprint project from a year ago, more or less, where there was some cleanup, but the ruts are still evident. We're going to make those ruts worse, no doubt, when we bring in our 65,000-pound equipment shelter, and we've agreed to restore that probably better than it is now when we're done. And that's one of the conditions that Diane's included here. So we think it's a very workable solution. We think it's that much of a better installation without the additional equipment shelter in the compound. Frankly, we think the Waterworks folks are going to like the location of our antennas where AT&T was at the top of the tower rather than on the side of the tower. It's less invasive to the tower itself. That was a concern, the structural integrity and not making penetrations and so forth. So we think it's a better plan. I don't know if you guys have had a chance to look at the 7 conditions that Diane had written up. they're all agreeable to us. We talked about them at length this afternoon. The posting of the bond, the painting of the antennas, providing an annual report on the structural integrity of our installation, where the access is provided, access coordinated through the town administrator, repairing any damage to the right-of-way, and no propane tanks on site until the access is acceptable to the fire department. Those are all understood and agreeable to us, and we welcome your questions or conditional approval along those lines.
Thank you. Peter or Mike, do you, on behalf of the Technical Review Committee, do you want to make any comments from your meeting this afternoon?
Well, from my point of view, most of the things that were summed up in Diane's note here with the 7 conditions, and the intent here is to keep from creating a boundary issue with the Ransdell family, while at the same time preserving the access that is deeded to the town and by way of easement, and then eventually some sort of an agreement to be made with the major landowner out back there so that complete access can be accomplished for the fire department and hopefully the LP tanks. That's pretty much what I took away from it. Mike, if you have something.
No, I think the only real issue that we spent any amount of time on was the notification to the Ransdells as far as accessing the property. It's determined that they will notify town administrator's office, and town administrator's office will then notify the property owners. It's just as a courtesy to let them know that someone will be on their property. That was really the only issue that we had, main issue. Obviously, the propane tanks not going up there until such time that there is a decent access road for fire coverage. Those are really the 2 points I think we discussed mostly this afternoon.
What would you have instead of the propane tanks, or until the propane tanks are in, you'd have what, a backup battery emergency or something?
Backup battery is standard part of the site, even if we had the propane tank. The propane tanks would power a backup generator, which is the third level of power redundancy. And in lieu of that, we'll equip the equipment shelter with kind of an external device where we can actually wheel in a portable generator for actual need occasions and plug it in from the outside, and it'll have its own self-contained fuel source and only be there during an emergency when we need to have that source of power.
What's the capacity in a time frame of the battery?
Batteries are about 8 hours.
Okay.
And a generator fully fueled is about 3 days.
Okay. Any other comments or questions? Yeah, Belle?
Do the Technical Review Committee have any reasoning why the burden of notification to the abutting property or the right-of-way property would come from the town as opposed to having the burden be placed on Verizon?
Peter?
I think it was, first of all, the lease consideration. In other words, Verizon has negotiated its lease with the town, and therefore they'd like to reduce any direct interaction with the homeowner.
Okay.
And since it's a town that wants to preserve the homeowner's rights as much as possible, we interjected our positioning in the chain, so to speak, of notification.
Just to tag on to that, I think it's not that they speak directly to the town administrator, it's just the office itself. For example, Kathy, they could notify Kathy, Kathy would then notify the landowner. So it's not like we're saying, no, you've got to talk to the town administrator to get permission to go on the land.
Yeah, I
Why
understand.
don't we add office to the
Office, yeah.
condition, number 5?
And Diana,
But it was the town administrator that,
The town administrator had presented that recommendation as well as the recommendation that, any disturbance to the area be restored within a week's time.
Yeah.
And I think it was the preference of Verizon that the town notify the abutter and work with the abutter because they weren't interested in having a third-party agreement be attached to their lease agreement.
Right, it's already in their lease agreement that that's the way that the process works. So rather than redo it and go through legal and everything, this was the easiest way to do it. And and then you've only got one person that's calling them, because what if further down the road, cell phone company B comes in, then they've got another set of people that are contacting them. So this way here, I think it can stay a little more constant.
Thank you.
Yeah, Val?
And just relative to conditions, any issues regarding disturbance that would be seasonally based, so you wouldn't be able to reseed?
Yeah, I noticed that too. I think a week is awfully tight. I'd prefer it to say something like as soon as practicable. If we finish up and then we have a 10-day deluge, we're not going to be in there, seeding and so forth. And we'll certainly do it as promptly as possible. But there may be conditions like that would make it stretch beyond a
Yeah,
week.
I would say that's probably.
And I guess my only other comment is more of a question is there any reason that Public Works would be notified? I know we have the fire department here, but when the propane tank is delivered, is there any impact or issue with the functioning of the water tank itself and the supply of any reason did technical review committee look at that, or?
I don't think we ever discussed DPW being notified of it. It was more, DPW goes up there now, the water department goes up there now frequently just to check it, and they generally walk into the site. They don't even drive up to it. I believe we were just looking more in terms of safety than anything else as far as the propane was set up, make sure that there was fire access to it, and that was the only concern that anyone seemed to really have. And understanding that the fire chief and the DPW head is one and the same, I'm sure if you would have had a question as far as DPW having a say to it, he would have said something at that point.
We have reviewed the plans with Rick Milasky, and before George Laney left, he was involved in the technical review at the department head level. And their primary concern was, the fire access, and, they wanted to make sure that there was an overture to the abutter so that they would be properly notified and there would be minimum interference to their property.
So Rick
will
be advised. He's on board, and
he's on board, and
he'll know when the
involved in
propane
this
tanks are
process.
going in.
Yeah, well, I think we talked this afternoon about actually requiring a further amendment to our site plan.
Right. And
So
it
that
does-
in the course
I-
of that process, department heads will get notified as standard fare.
And I reworded condition number 7 so that it says, to the satisfaction of the Newmarket Fire Department and the Planning Board, which implies that it would have to go back to the Planning Board for further review at that time.
Okay.
Yeah, because our current iteration of our plan still shows future proposed tanks, ours and AT&T's, and we'll just take them off altogether.
The final plan, yeah. Right.
I had one other question about number 5, the access, and I'd like to include in there something that says to the effect that, except in case of emergency, as set forth in the lease, because our lease agreement does have an emergency exception, that if we can't notify someone,
Okay.
we notify them as soon after we've made access as we can.
Any other questions? Any public comments on this? Any other questions or comments from the board? Do I hear a motion? Peter, maybe as a member of the TRC, maybe you could make a motion?
Yes, thank you.
Sure. I could have picked on Mike, but...
But you nominated him for chair, so.
I would like to make a motion that we accept the application of Verizon Wireless, subject to the conditions as amended, put forth by Town Planner Diane Hardy, 1 through 7, and that's it.
Accept and approve.
And approve, right,
And approve.
excuse me.
And can I mention, and also final, condition 8 is final plans that remove AT&T, remove propane tanks, and show relocated antennas.
What he said.
Show propane tanks removed and relocated antenna.
Yeah, make sure Erica.
The removes singular.
AT&T Wireless.
Do I hear a second?
I'll second.
Any further discussion? All in favor of the motion, please signify by saying aye.
Aye.
All opposed? Abstentions? There you go.
Now, would this mean we all get better service on our phones?
Can you hear me now?
Only if it's Verizon.
Only if you weren't counting on an iPhone.
Oh.
Next on the agenda, if I can get my agenda open, is a site plan review for Lamprey Falls LLC, Bay Road Tax Map U2, lots 359, 360, and 361, and one zone. Amendment of an existing site plan approved on December 11, 2007, requesting to lower the elevation of the parking lot by approximately 3 feet, eliminating the ADA ramp into the building.
Thank you, Mr. Chairman.
Good
My
evening.
name is Bernie Peelich. I'm here on behalf of the applicant, Lamprey Falls. Most of you probably remember approving this a while back, and with me this evening is Jeff Clifford, the site engineer, as well as Dave Lemieux, one of the principals of Lamprey Falls. Apparently, as this project got underway, it was discovered that there was not as much ledge as close to the surface as we had anticipated in the proposed parking lot. And as a result, it appears, and we are seeking a site plan amendment to lower the grade of that parking lot by varying amounts, but up to 2.8 feet at the greatest lowering. Apparently, this has been reviewed by Public Works Director, by the building inspector, by Farwell Engineering, Tobin Farwell, who was the peer engineer engaged by the town to review the amended plan. And it's also been reviewed, I believe, by the Heritage Commission. We have a favorable recommendation from the building inspector. We have a favorable recommendation from DPW, Mr. Mulaski. We have a favorable recommendation from Mr. Farwell, who has reviewed the plans. And I think Diane knows that Dave met with the Heritage Commission, and I don't know if the Heritage Commission has put anything in writing or not, Diane.
They haven't.
Oh, there it is, okay.
I discovered it.
So everybody that we've talked to is in favor of it. It basically reduces impervious on site. We're eliminating the handicap. We don't need that long handicapped winding access now. And so we're able to, and in addition, we're moving one of the stormwater drainage outlets by 15 feet and thus saving 2 large trees on the bank. And with that, I'll turn it over to Jeff Clifford if you have any engineering questions. Thank you.
Jeff Clifford, Altus Engineering. I just basically going to say what Bernie just said with a picture. This is the previously approved plan. It shows the ADA access that was coming out here, and if you remember during the process, the ADA ramp even went out further when we first started. But this had been cut back, and then that changes to this plan, which would eliminate that area of impervious here. It also eliminates some steps that are right here. So from safety perspective, people going in and out of the building, which they come in at the second level, they'll be coming in on a walkway at a very shallow grade, so it's going to be easy for them to get in and out without having to worry about steps and whatnot. So it's going to be a much better situation. As to accomplish this in terms of grading, just going back to the previous plan that was approved, grades were like 54, 55 up in this area, and to make things work, we brought it down to this low spot here, and we had a catch basin that discharges down onto the ledges down by the river. Under the new plan, where we had that 54 contour was through here, and now we've got like 52, 51 and a half, where it's cut down. And to be able to shape this and make it work, we had to move the catch basin over. When I showed the plan to Tobin Farwell from Farwell Engineering, the first plan we gave Diane had this catch basin over here about 15 feet. I didn't have all the information on the trees at the time that I did that. When I went out with Mr. Farwell, we just both agreed that it should go over the extra 15 feet, and because there's two trees right here, one's like a 12-inch tree, one's a 15-inch tree. Same idea, it would come down to this spot right here and discharge on the ledge. It was pointed out to me, I didn't realize it till today, that there was a typo in the invert of this pipe that comes right here on the final plan will be 2 feet lower. That was pointed out by the town engineer. So again, the grading changed here, and we had to adjust the grades here because there's no walkway, but also the amount of vegetation doesn't have to be impacted as much. So we also have the planting plan. Revised landscape plan, which includes, well, yeah, grab it. As part of meeting with the Heritage Group, series of hardwoods that remain down here. They're good-sized trees. There was some that were removed. But the concern of the Heritage Group was that you'd be able to see the cars from Route 108. And so we all kind of came to the same conclusion of something that goes there needed to be shade tolerant because of the tree canopy here that's on the south side. And rhododendrons and azaleas were brought up to be put in along here. And I think the landscape architect took that lead and did mostly rhododendrons split up with some other lower plantings of vinca and not sure what they all are, but it's the rhododendrons will be just the right height to so the cars will be much less visible all year round. So I think it was a good solution. In terms of stormwater, it's the same stormwater. Nothing's going anywhere different going to that catch basin. And over here, like I said, there's 424 square feet less of impervious. So with that, any questions of myself or the applicant?
Any questions? Peter?
Just give me, I'm just trying to finish reading this.
Yeah, here, you want my glasses?
It's a large
No, I had to take, I have
It's a slightly
bifocals.
larger one, it might
Yeah.
be easier to
Oh,
read.
no, I can see once I took the bifocals off.
I had a question. I go by that building and the work there several times a day because I live down Cushing Road. And you've been doing a lot of excavating there already. Is that just removing the old blacktop and that sort of thing that's there? That's all been done. That's all that you've done so far.
That's correct.
You have-
Curbings in.
Yeah, I noticed the curbings are going in today. That looks nice.
Some off-site improvements that were required by the previous approval, and part of that was removing the existing asphalt that's in the parking lot. We have not lowered any elevation.
Okay.
at this time.
Well, it's hard to. I know when it was paved that you could recognize it, but now it's.
Yeah, so no, to
Looks
answer
a
your
lot different.
question, we haven't lowered
Okay.
anything.
And the parking lot, if I remember correctly, had a drop like that down to that small building there. Are you going to lower the entire parking lot or just that upper part that was elevated on the building side of the lot?
The lower portion where the actual driveway is
Yeah.
is very, very close to original.
Mhm.
It's more lowering the higher part, which will eliminate that kind of incline
Right,
that we were talking
right,
about when we
okay.
did a site walk.
Right.
That's gonna be a lot less.
So the incline will be, maybe it was 3 feet now or 4 feet or whatever it was, it will be much less than that.
Much
Okay.
less.
Okay. And the other question I had was, there were a lot of trees cut down there. Was that PSNH doing that, or?
The trees that were cut down on Bay Road was some of PSNH, and some, a lot of them were us as well. We didn't cut anything that was over the 15-inch. And as you'll see, there's a substantial landscape plan.
Right.
And a lot of them were for that retaining wall that's going to be there, which is still there, but now it's going to be lower.
Right.
So a lot, it's going to, we think it's going to look a lot better. That was another reason why we wanted to lower that end.
And after these plantings are in, then that's basically will hide the cars that will be in the parking lot.
Correct.
And it's the same number of parking places.
Exactly. Nothing else. None of that
Just
has
lower.
changed.
Okay.
None of that has changed.
Any other questions?
Just a general question, it has nothing to do with the issue here, but can you explain to me the drain and how water is processed, or drainage is processed before it flows into the river?
Sure. The stormwater basically come down here, and collect to this one catch basin, again, that's on, shown here in blue. And in that catch basin, it has a deep sump, which collects the solids, the heavy sands and whatnot. And then there's a hood, and what that does over the outlet pipe inside the catch basin, the hood, if there was ever any greases or oils, would be trapped on the top, and it wouldn't, so if there was a wholesale leak, one could go pump it out. But the other thing that happens is that if there's just a sheen, basically it breaks down, gives it a chance to break down, doesn't get discharged right to the river. But the other thing that we did on this project, we don't do, you don't see in every project, is to put these things called smart sponges. And the smart sponge is this special product that's used to clean up oil spills, basically. And it's a product that can be in water. It doesn't absorb water, but what it does, it has an affiliation for oils. And so basically, if there is that sheen in this catch basin, it'll actually collect on that smart sponge. And that has to be changed periodically. And so there's basically a string that comes down, it's tied to, and you have to pull it out and replace it.
Thank you.
Yep.
Any other questions? Any other comments?
Who's responsible for the periodic maintenance of the catch basin?
The owner of the building is, but it's also, there's a note that describes in detail that the town could come in if they felt it wasn't being maintained and back charge. So that's right on the notes.
Thank you.
Say something?
I just had one other comment. Diane and I have been working with the town council on the easements. I just got the latest set of comments, and I will send those back to Tim Bates tomorrow with all of his requested changes, so that the easements should be all set then also. That's two easements. One, pedestrian access easement across the property this way, and the second is an easement between these two property owners allowing access over this property for this property.
Another question before you through on that particular subject. You're still dedicating some spots in the main lot to the
Yes.
tenants?
Yeah, those are still
4 spots?
4.
Thank you.
By the license, there's a license agreement which is between the parties if they choose to elect to use them.
Good, thank you.
Okay, thank you. Any other comments?
Can I ask a question? When they talk about the smart sponges, and Val asked who was responsible for maintaining it, is a smart sponge in the catch basin?
Yeah.
Okay, so is there going to be a record somewhere that shows that it's been routinely maintained?
One of the ways we've handled this in other communities is that there be like a operation maintenance schedule, and that once a year, the developer or the owner will do an inspection and send the report to the town, and
Okay.
the town would keep those on file as record that the storm drainage structures were properly being maintained.
That's on the plans.
I don't think that particular requirement is on the plans, but maybe if that might be a condition. Is that something that you would be amenable to?
Yes.
Yes.
That's fine.
So why don't we add that to
Yeah.
the conditions?
I might be overlooking this, but is there somewhere on the actual plan that would be approved this evening that references the condition of incorporation of the landscape plan? Or does that have to be as part of a condition?
As part of the approval, We do a developer's agreement, and it lists all of the planning documents that were submitted to the board, and they become part and parcel of the approval. So that if you approve it tonight, you would approve the submittals that were made, and they'd be incorporated into that developer agreement.
Any other questions? Comments?
No, I just think lowering it's going to make a nicer job.
Yeah.
I
I'm
think
glad you,
it's gonna be an
I'm
asset
glad you
to the
found
whole
you didn't have
area.
as much ledge as you
I
thought.
think everyone benefits.
But we have as the gentleman stated earlier, we have, Dan Vincent's weighed in favorably on this. Rick Malasky has done also the same thing. The Heritage Commission has also with a couple of comments, and I think you've addressed those tonight with regards to the rhododendrons and a new landscaping plan. There were a couple of things that we recommended. One is the technical comments that Tobin put into his letter dated May 14th be addressed, and you've agreed to do that. And there's something else about an underground irrigation system that...
That was one of the recommendations of Dan Vincent. In the landscape plan that was submitted, if you can read notes 17, if your eyesight is good, you'll see that it identifies two options for irrigation of the plants, one being an underground sprinkler system, and the second being an outside hose attachment within 150 feet. And Mr. Vincent had some discussions with Mr. Lemieux, and Mr. Lemieux has agreed to install the underground landscape system as part of, the plan approval. So it's being recommended that that notation be modified on the plan, and that be included as part of the overall landscaping.
Okay. So we have... my glasses back on. Don't get old. We have three conditions then. The technical comments on Tobin's letter, the underground irrigation system, and a stormwater structure will be inspected annually with reports to be submitted to the planning office. Do I hear a motion? Oh, I'm sorry. We have to do public comments. I'm sorry. Yes, please.
Thank you. Roseanne Quox. I'm here for the Advisory Heritage. And I was just wondering how dense, how big, and how many rhododendrons and azaleas you plan on putting in there.
I believe Roseanne has 20 rhododendrons there along the Main Street.
Along the Main Street portion?
Main Street portion.
Okay.
And then Robbie Woodburn, who did that plan, reconfigured the area where the handicap plan was going to be, and has incorporated a new design in that portion of it as well.
Okay. Is it just going to be rhododendrons or azaleas as
I
well?
believe it's a variety of...
Okay. And I see 3, 6, 9, 22, 20 day. Does that mean 20 day lilies?
Roseanne, up in the right-hand corner is a whole list of all the
The
plants.
schedule of all the plants and the sizes.
Okay. Daylily mix, Stella Supreme. If you, I see the daylily mix you have, Gordon Briggs, Custard Candy, Ed Murray, and Stella Supreme. If you put something like Happy Returns and the Stella Supremes, those are varieties that bloom continuously throughout the year. I believe the others don't. They just bloom once and then they're gone. Although he does have periwinkle and, all right, and the shrubs will be big enough to, so we don't see the cars from 108.
Well, I mean, you'll still know cars are there. I mean, we can't make them invisible, but we're going to do this,
For the rhododendrons, Mrs. Quox, it's 2 to 2.5 feet height for the rhododendrons
Initially.
initially, right?
2 to 2.5
And
feet.
I don't know how high these particular varieties grow.
And the high bush blueberries are 2.5 to 3 feet.
The high bush blueberries aren't deciduous, are they?
Yeah,
I mean,
they are.
They are
Sure they
deciduous, I
are.
mean. So, and where are those going to be put on here?
I think we're
Is
getting
it-
nitpicky.
That's the VAC.
We're getting a little nitpicky.
C.
VACC
I'm
is the high
sorry.
bush
Right.
blueberries.
Vaccinium
Okay.
They're going down.
Awesome. And those are spec'd out at 2.5 to 3 feet.
So are those in an area where, when they lose their leaves in the winter, that you're not going to have anything else around them? So that you don't see the parking lot?
That's
They sit
shown.
down over the edge more, Roseanne, they appear to be.
Okay.
They're right at this corner here, wasn't it? Okay.
Yeah.
It's 22 VACC.
Yeah, I see that. And then you have the Vinca minor.
Which is
And-
a common periwinkle's just a ground
Yeah.
cover.
I would think that, I would hope that the landscape architect recognizes the need to eliminate or reduce the view of the cars
Yeah.
from 108 the year round, so I would expect that he would have put in a proper amount of plants that would do that 12 months out of the year.
Yeah.
Okay. And, but 2 to 2.5 feet for rhodos isn't all that much. So I don't know if the board would entertain maybe at least 3 feet.
I'm not familiar with the varieties, but some of them do grow quite
Very
tall.
fast, yeah.
And very fast, I might add. But
Any other public comment? Any other comments from the board? Questions?
Well, I think they have groupings. It's like 2.5 to 3, and then might be
Don't they
3.
do it by gallon size or something?
Yeah, well, 3 to 4.5 or something is the next range.
The rhododendron, bunt-balled and burl.
They are all right. I deciphered that. If I had a catalog, I could look it up.
I think we're getting,
To the next
Yeah.
size
Okay.
range, if you feel it's appropriate. It's
What
up
does
to
the
the
board
board.
think?
It's up to the board.
I know Robbie Woodburn. She does a lot of her work on waterfront-type properties. She appears to be very conscientious and knowledgeable. So unless she was directed from a cost perspective by the applicant, I certainly would trust her professional opinion on what she feels would be appropriate there. And with a high certainty that these plantings, would grow and stay alive.
I agree with Val.
There is a notation in our developer's agreement that if the plants don't survive 2 years, then they would have to be replaced, and Mr. Lemire
Okay.
has agreed to that.
Yes, sir.
There was no cost. We never even mentioned the cost at all. We just told her to do exactly what she thought was the right thing to do. It was a $2 amount. Adding it all, we never even spoke about it.
I think I would agree with Val that we go
Mhm.
with the landscape architect's plan.
Mhm.
The fact that it's irrigating, you're going to see very vibrant growth.
That's right.
So we have, any other public comment? And we have the 3 conditions that I read earlier. Is there a motion to move forward on this site plan modification?
Mr. Chairman, I would make a motion that we accept the proposal to lower the elevation of the parking lot as specified in the plans attached to the application, approximately 3 feet, which would eliminate the ADA ramp and change the landscaping and drainage as noted, with the addition of the 3 conditions?
3 conditions.
3 conditions, I would recommend it for approval.
Do I hear a second?
Second.
Any further discussion? All in favor, please say aye.
Aye.
Opposed? Abstentions? Thank you very much. Okay, the last item on the agenda is, the last item on the agenda is other business. And if there's any other business from the public or from members of the board, I would appreciate a hearing. One thing I would ask for the folks who are watching this on television, we would like to have alternates. So if anyone would be interested in volunteering as an alternate to the planning board, please pull off an application off of the town website, fill it out, and submit it, and we'll move forward. I see someone in the audience that could be an alternate, but...
Yes.
Yeah, that's what I was thinking when you walked right in.
Any other business?
No, but can I make a public announcement? Can I make, since I don't have a TV station, on Tuesday, May 27th, the Newmarket Veterans is going to be sponsoring another, it's our 9th roundtable discussion, and the event is open to the public, and we put a slide up on the TV, but in case those people have a hard time reading the slide, I just want to make it known, and it starts at 2 p.m. here in the Town Council chambers. Thanks.
Thank you. If there's nothing else, do I hear that motion that we're looking forward to?
I have
Oh, I'm
something.
sorry.
Town Administrator Winowski has brought to my attention, I believe it was discussed at a town council meeting, that there could be a potential violation of an approved site plan and our site plan regulations out at the Newmarket Industrial Park. There apparently has been some up to 36 storage containers that have been brought in to the site, which was not included on the approved plan. And the administrator has asked me to review it with the board and to investigate it, and if there is a violation, that we work with the property owner to try to get it resolved, and it will likely result in having them come back before the planning board with a revised site plan.
If I understand the process, and Diane, correct me if I'm wrong, the process is that the code enforcement officer would be the person that would come back to us after review of the situation and a review of the approved site plan and tell us, in fact, that there is a violation. Is that correct?
Right. And then with the board's concurrence, we would go forward with an enforcement letter, just informing the applicant that there appears to be some violation and giving them a reasonable amount of time to come back to the board and come in with a revised plan and to rectify it. So that's
Okay.
really, the first step is really to, do it in a cordial manner to try to work it out outside of a, enforcement action type situation.
And this involves temporary outside storage,
It involves storage containers that have been brought in and stored on the property, and there's upwards to 35 of them.
They're landed
And
on the
they're-
ground?
They're on the ground, and some of them are stacked up on top of each
They're
other.
not on wheels, right?
They're not, there are some storage trailers that are on wheels, but they're in appropriate locations at the loading docks. We're concerned primarily with the storage container, the boxes themselves that have been brought in.
And these are the 20-foot kind of steel shipping containers or ocean
Yes.
containers? Yeah, okay.
20 to 40s.
20s and 40s, right? Okay. Well, what does Dan need? Does he need,
I think it would be helpful if, if the planning board made, or directed him to investigate the matter and to report back.
report back?
And then we can take further action from there.
All right. Any discussion? Questions?
I'm just confused. I think that Diana's contradicting what you said earlier. Should Dan be coming to the board with the notification of violation for us to investigate first?
No, that's not what I said.
Okay, I misunderstood that.
We would like to have Dan investigate, take some photographs. We'll take a look at the previously approved site plans, and at the staff level, we'll make a determination whether we feel that there's a violation, and then we will bring that to the planning board, and then we'll proceed from there.
So we won't have any action until that time.
Until they come back, right, that's correct.
I just think we need to get all the facts together before we go forward.
Yeah, of course. Any further questions?
The only question I have is, I mean, with Dan having known about this now for, well, since he came back, I'm not sure how long that's been, you know, has he taken any steps at all to, I do believe he does have photographs, correct?
He does have photographs, but I don't think there's been any formal notification sent out to the abutters. And I'm just following up upon, I think, was there a meeting with the town council concerning this subject of just generally storage containers? I know we had a meeting.
I know
and
we
talked
had the
about it.
meeting with the town administrator, and it was discussed, and at that point, that's when I think I actually saw the pictures that Dan had.
Right.
But I guess, you know, if there's a violation, I would like to think that he would bring it to us immediately, as opposed to us having a discussion about it this evening, saying, okay, Dan, go and take care, you know, get the wheels rolling on this thing. You know, violation is a violation.
Maybe he's trying to work on it.
I think
Does the town not have policies and procedures in place for violations of subdivision regulations? Well, why, I guess I'm confused as why it would come back to the planning board unless that was at the point in time
I think-
where you would be revoking the
I-
subdivision approval.
Administrator Winowski wanted the planning board to be aware of it before going forward with the letters to the property owner.
Well, I think as the normal course of his job, he should be doing this, as Mike just discussed, but if he needs some,
I think he's looking for the support of the board on this.
if he wants the support, as far as I'm concerned, he's got it, but,
It's a violation.
Yeah, I guess.
I'd like to know more before we give him support. I mean, we haven't seen anything.
On all
right?
plans that have been approved. I guess I'm confused.
I mean, there has been time to check and see if there's been approvals given for those units down there, and obviously there hasn't been, so, I mean, it's a violation. And, you know, as you said, why, what are you looking for the blessings of the board for? You know,
Just go forward.
yeah, I think you have to. And, you know, I mean, this is a major, I mean, this isn't, you know, a boulder that's out of place. This is, you know, 30-some containers, which equal to how many square feet of warehouse space that's not being taxed at warehouse space?
well, we're not in the taxing business.
I understand that, but what I'm saying is, you know, that this is, in essence, what they're using them for, and we don't know what's in those containers.
Okay.
Well, I'd like to see, I don't think the board at this time should be giving Dan any direction. I think Dan should be, and I'm sure knowing Dan, he is probably working with the, whatever company you mentioned, I'm sorry, I didn't hear it, and to work a solution out, because we don't want to have other businesses leave our community. We would rather work with them to make a happy solution for everyone. And I think coming
Certainly.
tonight, saying this out in public without us having any background information was unnecessary, because I have no idea what was being, you have other information that we're not privy to, and I feel kind of lost here.
I was asked by the town administrator to bring it to the planning board's attention, and that's what I'm doing.
Okay, you have. Yes, Rosie?
Roseanne Quarks, Wiley Falls. I was just wondering why the town administrator was involved in it. Shouldn't it be if the code enforcement officer is aware of a violation? Is it his authority and his authority only to take care of the situation, to go out and send a letter and take care of it? I don't see why we have, like Mike said, these steps. Why was Dan able to just do that on his own? Is that part of the policy?
Maybe he needs to be authorized to go forward on his own. Maybe under previous administrations, there might have been different policies. I don't know. I mean, I really
I mean,
can't speak for
you know,
Dan.
I believe
But I
that he
think
should be
he's-
allowed to do what he has to do without going to anybody, and if he finds that information, informs them that there's a violation. If they don't correct it, then they would have to go back before a planning board. That's when the planning board would hear it. But I believe that Dan should be allowed to
Try and resolve the problem.
to,
Yeah, I
to,
agree.
to do what he's,
I
to
agree
do
with
his
you.
due diligence.
I agree with you.
Yep.
So you've made us aware, and,
But we will go forward, and we'll keep the board appraised.
and
Is that a
if he can't get it
satisfactory
resolved, and he needs to raise it to the next level, which would be the planning board, then, because of the site approval violation, then let him come in and tell us.
Okay.
But, you know, it's a normal course of his job and his responsibilities. He needs to go out and first try to solve the problem. Okay?
Okay. Thank you,
All right.
Mr. Chair.
Peter.
Thank you, members of the board.
Next. Diane, we made the list in the workshop that we had of, charting all of the things that we wanted to do with the mill and how we wanted to go forward. Where does that stand?
With the mill.
The mill redevelopment.
Well, that's a good question. As you probably know, we had a non-binding referendum vote 2 weeks ago, and it did not pass. It lost by, I think, 40 votes. And I think, I'm not sure where things stand. I guess I'm looking for some policy direction from the town council and the town administrator, whether we continue as we were doing, or whether there's been some kind of change in policy that we need to be aware of. And I don't, given the transition with the new council coming in, I don't think that issue has been
There seems to be no end to my confusion.
sorted out.
The referendum came up to see to it that there was a residential component in the zoning for the mills, and there's already a residential component in the zoning for the mills. Why is everybody excited about that? What we've got to do is we've got to lock in on what's our tolerance. Where do we want to set the limits, and what do we want to do with the existing zoning uses, allowed uses, that are already on the books? Do we want to strike some? Do we want to add some more? Do we want to take into consideration the current market situation? We've got to do something, and I think the meeting that we had, the joint meeting that we had with the council, was useful to me in impressing me on the fact that we're dragging our feet. And I don't mean the planning board, I mean, it just seems the whole process seems to be bogged down. We've got to get up and be proactive and get something done, even if we say we don't want to do anything. But we've got to do something. We can't just keep sloughing it off. And I think that if we use the referendum as an excuse to say, well, the referendum didn't pass, it doesn't mean that the mills went away. It doesn't mean that the need to handle a problem has gone or is tabled. We've got to do something, and I think we've made a good start with that technique that you brought forth, and I think we should follow up on it. And I'd like to, one of the things, and I know you're busy, but if you have a chance to summarize what we put together there for each of us, and let us do some independent thought, and come back here and, make it one of the agenda items at the very next meeting, so that we can at least, roundtable it for half, three-quarters of an hour, whatever it takes, to get to the next step. So that we don't have to sit down again in joint council meeting and say, gee, I don't know, what do you think? Because that's not my way of doing things. I know it's not yours either. So, I'd like to get going.
Well, maybe to save Diane some work, when I was reading the meeting minutes that Sue put together for me from that prior meeting, Diane had stated at the end of it that she would summarize everything that was presented and discussed, and I'm thinking to myself, why are you summarizing it all? It's right in the meeting minutes.
Well, there was a
That whole list was in the meeting minutes.
I didn't see it.
Talking about every little service, or type of business or retail or what the vision, that's well defined within the meeting minutes. Must be Erica's great note-taking.
Of course.
And along those same lines, I think it's important that maybe the planning board revisit the various visioning programs that have been done in the past here, as opposed to trying to reinvent the wheel. There's been 3 of them done in the past 8 years that have been actually facilitated by professionals who are doing similar to Diane, but doing community planning. And those visioning charrettes, if you will, were joint programs with the collaboration of many different organizations in town. So there's a lot of data that's already there, and that's already, certainly a lot of investment has been made to, for these charrettes and the outcomes of them, and it may be beneficial, if each of us as planning board members review that documentation or that information, as opposed to, trying to reinvent the wheel at this board level.
A couple of comments I have. One is that, as I understand it, the NCDC is appealing the ZBA decision, and that's moving forward. And the second thing is that we're kind of waiting here, and I agree with Peter that we need to be proactive. We have a town council member here and a town council member sitting in the audience. Are there any comments that you can add from the town council? I know it's a new town council. We just met Monday night for your organizational meeting and so on. But is there any input that you can give us? Secondly and thirdly, I would have thought that in view of the vote last week, that maybe the NCDC would be here talking about a new direction and where they would want to go with help from the planning board, and they're not here tonight. So I don't know what their sense of urgency is, but Ms. Quacks, if you had some comments, that would be appreciated. Maybe we have a higher sense of urgency than others. I don't know.
And I'd like to clarify to the public that what the NCDC is doing, they're not appealing to the ZBA their decision. They're suing the ZBA board. They're suing the town of Newmarket, the ZBA board, for the decision they made. And
Appealing it to Superior Court is basically.
yes, but if you read the language, we are being sued by, Newmarket is being sued by the NCDC. And Val, are you still a consultant to the NCDC and
No, I'm
attending?
not.
Are you attending any of their meetings anymore?
No, I haven't for over a
Okay,
year.
because I knew you were involved with them. And and also sleeve, what's the name? It's not Suflex now, it's
Oh, Regal Sleeving?
Regal Sleeving. I believe they're closing, and there's going to be 40 or 50 people laid off there. And I just think it's a sorry state that the NCDC is suing the town about this. If they could have come back to the ZBA with something else, we could have more than accommodated them. And I just don't think it's the way to do it. And I'd like to also know, are they using our money to sue us for legal fees? I
Well,
mean, it's just,
Another story.
it's not right. Just isn't right.
Mike?
I think to answer your question, initially, I believe the council set it up that they preferred the planning board to set the wheels in motion and give the council something to work with. And I think that that's really what the process should be at this point. Do the diligence here, try to come up with a plan, present it to the council, and let the council work on it, let the public hear what's going on, and get the input. I think that perhaps answers your question.
Well, the problem I have is that if there were 1,000 voters and 950 of them voted in the affirmative for that referendum, then to me that was the town saying, you guys charge ahead, but it was defeated. Not by many votes, but it was defeated. So now I'm sitting here scratching my head, saying, as a planning board, what the town's saying, no, don't do that, by that vote. I don't think personally, and I'm just speaking for myself, I don't think that's necessarily what I'd like to see as a resident and a taxpayer. I'd like to see those mills developed.
Right. And
But that's not what the people said. They
But
just
that's
said-
not what
But see,
that's
now,
right. So
and the
where do we
question
go
that I
from
have is,
They didn't say not to
the question
develop
that
it.
I have is, if it had been
Develop
40 votes the other way, how quickly would we have reacted to that?
At
Probably
least
no-
it would have been in the affirmative.
But, I mean, the biggest problem we've got is we've got a situation where we've got a potential asset that is deteriorating. I mean, it's just going away. And, you gotta decide if you want to see something there. And, quite honestly, at this point, it's on the planning board's back, because the council has asked, give us some guidance, give us some directions, give us some ideas. That's where we started to go with it at that meeting. And as Val says, you don't want to reinvent the wheel. I think a lot of those applications that were put down that evening were applications that were already, perhaps even in the RFP that went out. But I think, from a standpoint of doing something about it, if you sit here and do nothing, then that's exactly what you have, is nothing.
I agree with that.
But you know what, I don't think the mills can be developed. That warrant article, that non-binding warrant article, didn't say not to develop the mills. There was a lot of confusion out there in the public's eyes, and I think right now, as Mrs. Quack indicated that NCDC is suing the town of Newmarket, I think that just put a lot of negativity out in the community, where we should be sitting down with NCDC saying, okay, this is the current zoning, let's all work together to see what we can do with the mills.
And
Now
also,
it's, I think, it's muddled the water.
and I'd like to know why the NCDC isn't coming forward and letting the public know, the planning board, council, and ZBA, were there any other RFPs that came in that are viable developers? And why aren't we hearing about them? If there's 1, 2, or 3, why aren't we hearing if there's any other options out there that could possibly come before the ZBA to be approved? And they're not doing that. They are not doing anything. And it's I'll tell you, people are not happy about it at all. And they should be disclosing all this information publicly. The cloak and dagger's got to stop. It's ridiculous.
For sure.
And also, are we limited because we're being sued as to what any board can do? I mean, that's a question I'm not sure of.
We had this process going prior to being sued.
Well, it's the ZBA and this is the planning board, so I don't think that's an issue.
Well, I would like to.
They're appealing, and I've read the whole suit that was filed. They're appealing the decision of the zoning board based on the zoning board's position on some of the criteria. So that's an appeal to the court.
As I understand it, it is part of the process to get it before the Superior Court.
Correct.
Right.
Which is the route they have to
And I
go.
think they use the terminology of suit, just because that's
legal.
legalese.
It's court, it's a suit.
Yeah.
I mean, basically, they're asking for an appeal to the decision of the ZBA. They're asking the court to review it and to render an opinion, or to even remand it back to the local zoning board to reconsider.
Well, and it seems to me that that's how
I mean,
zoning
it doesn't
law-
necessarily have to be viewed as an adversarial type thing. They're in a disagreement with the
process.
opinion, and this is the process they have to go through. I think it's just the terminology that was used that appears that it's an adversarial type thing.
But I think it would help the planning board and the ZBA and the council to have the NCDC let everybody know publicly how many applicants they had that were viable, what their plans were, what their numbers were, and to come before them and let the public know and let the public make a decision instead of everybody spinning wheels and going to court. It's a waste of everybody's time, energy, and money.
Peter, you had a comment?
I think there's a couple of things. First of all, I still think that the wording of the non-binding referendum was ambiguous, and it was confusing, and a lot of people voted on it thinking they were voting for one thing, and it didn't say that, and so forth and so on. But the other thing is, I think it's still up to us to recommend to the council what the ground rules should be. And that's where I'd like to start, and I'm not worried about NCDC and initiating action to overturn the zoning board decision, however it's termed, as it's a suit or it's a whatever it is. It doesn't make any difference. It's still the responsibility of the planning board to put together these guidelines and put them in front of the council, and the council can make the decision on what they want to do.
Well, for sure,
We've got to take, we've got to take this first step.
the town and NCDC will not get another developer in here until something's done.
Correct.
Sitting the way it is now, unless there's some, as Ms. Quack said, unless there is some other respondee to the RFP who might be willing to accept the density that is now on the books, but we don't know that. We don't know that. So I agree that maybe, Rob, sir, maybe this could be our new alternate.
When Arlen was here representing the NCDC, he told us that there was one other developer and it was of similar density. So I don't think that that's something to get mired into.
We should know the exact number.
He gave us a number.
Thank you.
I think this also goes beyond just the mills,
It
because we're not
does.
trying to do spot zoning. I think we need to take proactive measures in looking at the current zoning, modifying it potentially as necessary to make sure that that whole downtown area and the whole mill district and up Main Street is going to be viable for redevelopment for what the town wants to see. I mean, it's not just about the mills, it's about this huge untapped tax base at the end of Newmarket, that taxpayers are just, waiting to benefit from.
And to tag on to that, I mean, you've got the M4 zone, which, I know is sooner or later going to come before somebody to change, because they want to sell that piece of property.
Right.
And
We've had 3 or 4 inquiries from different developers who
so,
are interested.
I mean, this is something that's the board ought to get used to. I mean, the people are going to be requesting us to make some changes, or requesting the board to make some changes. And nothing becomes more spot zoning, as you just said, as that M4 zone, because it's specifically there's only one piece of property in that zone.
Well, there was 2, but now they're turning into residential. With a new house on it.
That's right.
But I think it's important. I think we need to look at the zoning, and possibly, have some joint meetings with the NCDC relative to their experiences with the developers and the consultants, that they have hired, particularly economic development consultants, of having zoning reflect something that is viable, that we can get a developer in here. Otherwise, we need to make the decision as a town of how much subsidies, if you will, that the town is willing to invest in some of these areas in order to, achieve the vision that the town wants.
Is this something that might be appropriate for a joint workshop with the NCDC in the next couple of weeks before the next meeting?
I think that'd be a great idea.
Is that something that would be of interest to the members here?
Well, no, you're pushing it. I mean, some of us are on other committees here. And yeah, I think I like to get the communities listening to this and get some feedback from the community, because each one of us is voted by different groups of individuals out there. And I think we need to get some feedback, because the mills can be developed. Right now, they can be developed. And there's no one's saying not to develop their mills. Their concern, from what I'm hearing, is the density. And if we talk about right now rezoning, when you had a non-binding referendum with the majority of the people who may not understand what that article was about, we're going to be in big trouble. We're not going to have any trust within the public, because certain people here want that done and certain people don't. The public has spoken now. I think what we need to do is work with what we've got and work with NCDC and work with the town. Maybe the town's got to get involved to come to a viable solution, like Val has mentioned, for everybody. But I think we're going to be in big trouble if we turn around and dish what the majority, even if it's by 40 votes, has said to us. Especially after what Roseanne just said about they may be going to court on the appeal issue. Doesn't sit well, I think, with a lot of people out there who have heard that.
Janice, excuse me, the only thing that bothers me is, what did they say to us?
Yeah, I mean, what does it really mean?
The referendum was so ambiguous that I don't know that they said anything. You can read it one way and say, I'm for the redevelopment of the mills, I'm going to vote yes. Or you can read it another way and say, I don't want 450 people a day crossing over 108, I'm going to vote no. It wasn't about that. It wasn't about anything.
Well,
it's very vague.
And it was non-binding.
It is.
But I do think,
And there's a lot
I
of
agree with,
miscommunications
I
and
do agree with
misinformation.
Peter and others that if we don't do something, it's not going to look well on the planning board, it's not going to look good for the town, and we will lose that asset. So I suggest that we try to pull together a workshop with NCDC, and we have at least one town council representative so far on the planning board, so there's a representative from the town council, and we try to move forward on this. What are viable solutions and what things aren't viable? And if we can set up some kind of a workshop with NCDC, then we need to do that. And I think I have personally a sense of urgency that we need to move forward on this.
Mr. Chairman, would we want to set up a separate meeting from our regular business meeting to focus on this issue? Maybe have a meeting,
That would be my
second
preference, but
meeting
I
in
would
June?
I'd like to hear from the members here. In a separate meeting, or we want to try and do this at the June planning board meeting?
I think if you do it separately, then you're focused on that one issue for that evening.
I would
And
agree.
and to me, I think it's critical to get as much said by all parties as you can that evening. So for me, I would think, I may not be here, depends on how these things shake out with the council and everything, but there will be someone here from the council. But from my perspective, the more that you can get accomplished in that one evening, just focused on that one issue with that group, would serve a better purpose.
And I would just like to ask that it be public and that the NCDC has as much information for the public as possible, including any other applicants that, and the numbers that they had.
I would
Well,
encourage
it will be a public
Ask
meeting.
them.
Yeah, I would encourage it
All
to
right,
be public.
we can ask them, Mrs. Quan.
So what I,
What's the sense of having the meeting if they don't bring all the information forward so everybody can make a rational decision? You need the information to make the decision.
so what I'm just hearing is whatever went on in the last 2 months was
No,
a
it's the
bunch of
10th.
waste of time for everybody.
24th?
Because this board's going to change the zoning anyways, it sounds like tonight.
And you probably don't even have to do it.
Well,
We don't know what changes are going to be.
we don't know what the changes are going to be, but I think it was just made obvious.
How about the third?
And I think we need to put density limits, because that's the biggest concern in the public's eyes when these developers come. And I think you're going to find a very hard time with any developer coming in, and I can see Diane making faces over there at Rob, and Rob making faces back.
Sorry, I just don't, there are many communities that don't have any density requirements in their
But
downtown area.
you know what, Diane, this is
And it's-
Newmarket. I'm not comparing us to any other town. This is Newmarket.
And
And what I'm hearing from people is the main concern is the density. And I think that's what you have to focus on, is the density. That's what people are saying. And you heard developers say that it's not going to be viable for them unless there's a certain amount of units. That's all I'm saying. I think this whole thing was a waste of people's times then. It sounds like this board is going to be changing the zoning, probably to accommodate a developer coming in.
Dennis, I think you're making a lot of
Well,
assumptions here.
You're talking about having a special meeting, and we've already heard NCDC.
I'm talking about doing something about it. I'm not talking about what.
I know, but we've
I
all
don't
heard what
want you to assume
NCDC.
that I'm a 150 per acre guy, because that's not necessarily true. So just be careful what you assume.
And the other issue, when you talk about density, that's a very vague kind of concept. You could go by density number of bedrooms versus units. If under the current zoning, it was done for student housing with no variance required, you would have many, many more people there than you would with 151 units predominantly being one bedroom. So density is a
And that's not
relative
really
term.
correct either, Val, to state that. That's also assuming something else, and people keep throwing out student housing as to scare people in the public.
Well, I'm just saying what's
Uh,
allowed in the current zoning.
I know what's allowed in the current zoning, but what I'm saying is, if we change the zoning, and you heard the Mills developers, I heard Alan say they've gone through how many years of doing this? How many studies, how many professional people have come back, how many developers have walked away? And they all said, to make it viable for those developers, it was the numbers. And that's all I'm saying. If you change the zoning, you may have to change the numbers to make it viable for what we've been hearing NCDC say. That's all I'm saying. I just needed to vent.
You vented. What I'm suggesting is that we have a workshop jointly with NCDC, and that's the first step in the process. We'll take it the second step after that meeting.
It would be
And
nice if they dropped the lawsuit.
we don't have anything to say about that.
I know, but I mean, that's really,
And it's the ZBA, it's not the planning board.
I know.
And whatever we decide as a planning board is going to go to the town council anyway. And we let them hash it out and make a decision. So I'm suggesting, and personally, as I said, I have maybe a higher sense of urgency than other people do. I would like to have some kind of a workshop with NCDC, if they're available and you folks are available, before the next meeting. Our next meeting is June 10th.
Oh, I can't do that, that's too quick.
It's one night.
No, I'm on other committees that take a lot of time, and I'm not against sitting down and doing that, it's just too quick.
I think, I would hope that the NCDC...
The mills aren't going anywhere.
They sure aren't. I would like to get moving on the process, that's all. And what does June 3rd do for the rest of you?
June 3rd, I have a meeting with a top-notch architect who's donating all their time to the Veterans Committee for our committee, and I do not want to dish that
Yeah,
meeting or
I
cancel it.
understand that.
He's volunteering his time, JSA.
How about the 27th of May? It's next Tuesday.
Nope. I can't do next Tuesday. I just told you I'm doing tapings all day. You don't understand how much work is involved. I'm not against coming, I just don't think within 2 weeks we have to rush into it.
We
all.
certainly can't be accused of that.
What do the rest of you
Can
think?
you do a different night than a Tuesday?
Yeah, sure.
I mean, that would be easier for me, if you,
What about,
I mean, I don't know what everybody else's schedule is like.
What's the first Monday of, is that the 2nd?
That's the 2nd, yeah. Is there a town council meeting that night,
They
Mike?
usually meets on
I
the
don't know, I don't believe we've actually scheduled the organizational meeting. I don't know if that'll take place on the 4th or if they'll do it prior to that.
What about ZBA? Are they meeting that night?
The ZBA will meet, if they meet on Monday night.
Well, we don't have any members on CBA.
Roseanne's a member.
Yeah,
The planning board.
yeah, but she probably should exempt herself if she's on the ZBA from the meetings.
We have a June
don't know what
9th
the-
meeting. ZBA.
June 9th. Okay.
June 9th.
Thank you, Roseanne.
Okay, thank you.
There, that works.
What, Monday the 2nd?
Yep.
Monday the 2nd? This is subject to agreement from NCDC and their representatives. Diane, could you make that
I would
contract?
be more than happy to, and I will also ask them to provide as much information as they can for
Yeah,
that
prior
meeting,
to it,
so we
for
have
right
that.
away, so that we can see it and review it before June 2nd. All right?
And what time?
7 o'clock.
7 o'clock here. If not here, then find another room.
Excuse me.
It'll be a public meeting, of course. Okay, thank you very much. Anything else?
Motion to adjourn?
Second?
Any discussion? All in favor?
Aye.
Say aye. Opposed? Okay. Thank you very much.
Thank you.
I won't put this on until I get outside.